Good evening, and welcome to the Brennan Center for Justice's third event of the spring season. This is titled Corporations and the Constitution, Adam Winkler in Conversation with Dahlia Lithwick. At this time, I'd like to ask you all to silence your cell phones, although we would love to engage with you on social media, on Facebook, on Twitter, @Brennan Center, or using the hashtag BCJLive. We also have two upcoming events I'd love to tell you about in collaboration with Carnegie Hall's celebration of the 1960s. The first will take place on March 6th, and it's about voting rights. The second will take place on March 20th, which is about the Great Society. After this program, Professor Winkler has graciously agreed to sign copies of his new book. You can buy one and get your copy signed in the library post-event. And with that said, our distinguished guests will come out shortly. Again, please silence your phones and enjoy the program.
Oh, they know. No, they don't. Welcome. Good evening, everybody. I am Michael Waldman. I am president of the Brennan Center for Justice here at NYU School of Law. And we want to welcome all of you to this really important topic, this really exciting conversation at a critical moment for our country. First of all, I want to thank our colleagues at NYU School of Law and my colleagues at the Brennan Center for staging this and so many other really remarkable gatherings and conversations this spring. You heard from my colleague a little bit about two upcoming events that I want to tell you a bit more about. Carnegie Hall, as you may know, is holding a festival all over the city. And it's some music, some cultural events, everything from the Schomburg Center up in Harlem, and the Apollo Theater, to the New York Historical Society, to the Public Library, and here at the Brennan Center at NYU. We are not going to sing or anything like that, but what we're doing is we are hosting, as you heard, two panel discussions on the legacy of the 1960s, and that's the theme of the whole Carnegie Hall thing, is the 60s, and we're looking at the 60s as a matter of social policy and public policy and its continued relevance and centrality today. And the first event is on voting rights. And it is on March 6th, and it's actually here in this auditorium, I believe. And we're going to be hearing from Bill Moyers, who was, of course, President Lyndon Johnson's press secretary and top aide at the time of the enactment of the Voting Rights Act. And he will be in conversation with Myrna Perez, the head of the Voting Rights team at the Brennan Center, and Kristen Clark, the leader of the Lawyers Committee for Civil Rights. Voting rights then and now. The same fights, the same rights in contention. And then later in the spring, we'll be talking about the Great Society, then and now. And that will be a conversation between Joseph Califano, who was President Johnson's domestic policy advisor during the Great Society. He was known as the Deputy President for Domestic Affairs. And he will be in conversation with Karen Tumulty, the newest columnist for the Washington Post. Again, the relevance of the Great Society and its programs then and now. And it's an amazing thing when you think about it that we're fighting today about the Voting Rights Act and about Medicaid in the fight over the Affordable Care Act. These were things that were enacted around the same time in 1965. They're still under attack today. And we have among us, the architects of those, with the people who are covering or fighting over these things right now. It's very cool, and I hope you can join us. The Brennan Center, as you know, is a nonpartisan law and policy institute. We work, as we see it, to reform and renew, and when necessary, defend the systems of democracy and justice in America. We were started 2 decades ago by the clerks and family of Justice Brennan when he left the bench as a living memorial. And I am told, I was not part of the Brennan Center at that time, I am told that they went to him and said, Justice Brennan, he was obviously, had just left the bench. They said, how do you feel? We want to do a living memorial. We don't want to put up a statue. We want to create this center. Is that okay with you? And not surprisingly, he said yes, that was fine. He said, under one condition. He said, I will be up there watching. And if I see that you are just trying to follow my views on everything, I will be really mad, because that would be originalism. And you know what I think of originalism. So in his spirit of the living Constitution, we try to take his values of the law revolving around a concept of basic human dignity and a constitutional order revolving around the values embodied in that Constitution, in the Declaration of Independence, and apply those values to the institutions of our time. And we believe those institutions are urgently in need of repair. They are urgently in need of reform and reclamation. We work, as you know, on voting rights. We work, as you know, in the fight to end partisan gerrymandering, which has an extraordinary possibility of real success at the Supreme Court and around the country. We work to end mass incarceration, a racial, economic, and social calamity. We have, as you know, 5% of the world's population, but 25% of the world's prison population. And that's wrong, and we don't need that to keep our country and our communities safe. And these are all issues that have been around for years and have been festering long before Donald Trump became president, even thought of running for president. We face now new challenges, challenges in many ways to the very norms, the very traditions, the very constitutional order, the checks and balances that keep us free, and that turn out not always to have been written down and often to be flimsy. And so we are working with people from across the country, from left and right, Republicans and Democrats, to fight to defend our constitutional order and defend our democracy from these new challenges. The work includes our pioneering work, led by my colleague Larry Norden, who is here, to keep the Russians from hacking the next election. Legislation based on our work is beginning to move through Congress, introduced by Senator Lankford, a Republican from Oklahoma, and Senator Klobuchar, a Democrat from Minnesota. We are looking to see what are the solutions, what is the next wave of reforms that can restore some of the accountability mechanisms that we took for granted. We have a task force that is being launched, co-chaired by Preet Bharara, the former U.S. attorney, and by Governor Christie Todd Whitman, of course, a Republican governor of New Jersey, to set out exactly what kinds of reforms would make sense. This is a critical moment in the fight for our democracy, and we at the Brennan Center are thrilled that you're here and proud to be able to be part of that fight. Part of this moment, part of this movement, is to join in a conversation about the depths of the challenges we face, and that is really what is exciting about this evening and the book and research we're going to be talking about. We will hear from Adam Winkler. Adam is a professor of constitutional law at UCLA Law School, a graduate of NYU School of Law. He is a active board member of the American Constitution Society, one of the most widely quoted explainers of the Constitution that there is out there. His previous book, sadly relevant today as ever, is Gunfight, which is a path-breaking look at the true history of gun rights throughout American history and the way that gun rights and gun laws have gone together, that challenges the views of left and right on this issue. It's had a tremendous impact. And his new book, which he's here to discuss, We the Corporations, about the drive for corporate civil rights, as it were, that led to Citizens United and Hobby Lobby, but turn out to have much, much deeper roots, for good and ill, in American history. It's sort of, you wouldn't think that a book of legal history could kind of blow your mind, but this book actually does. And we are really privileged to hear from, and in conversation with Adam, Dahlia Lithwick. Dahlia is, of course, in so many ways, the preeminent, or one of the preeminent, legal journalists, explainers of the Supreme Court working in America today. Donald Trump said to Sean Hannity that he was the Edward R. Murrow of the Russia scandal. I think that Dahlia is the Edward R. Murrow of the Supreme Court these days, or the Sean Hannity. That's take your choice. Among other things, Dahlia writes for Slate magazine and is the host of the very, very popular podcast, Amicus. And we are thrilled to have her as a recent arrival in Brooklyn and here to interview and converse with Adam Winkler. Thank you both for being here.
So I want to start by just thanking Michael and all the organizers, thanking the Brennan Center and NYU and all of you for coming out tonight. It's really an honor to be in conversation with Adam. And as Michael said, Adam did not expect guns to be a thing right now. So I don't know how many dozens of interviews he's done about his last book. I know he did one with me last week, so he's in a strange moment where he's talking an awful lot about the other thing, but we're going to try to talk today about this thing with the caveat that I'm going to probably ask a question about guns, and you can too. And we'll leave heaps of time for questions, because that's always the best part. But I want to start, I guess, by saying congratulations. This is a tremendous book, and a really kind of counterintuitive and deep book, not what I expected. But I think that, and this, at the risk of sounding Slate pitchy, Adam, I think I want to say that the subtitle to this book could be Corporations, You're Doing It Wrong. Because I think one of the things that you do is pretty systematically debunk some of the ideas that progressives have really bought into hook, line, and sinker about what's wrong with corporations, you know, the original sin that is Citizens United. And so I thought maybe we could start by poking through some of those, because I think that, to me, was the really arresting part. So maybe we can start with the story that I think most people tell, which is that America was founded by people who were seeking individual liberties and rights and religious liberties, and that these wretched corporations bump along 200 years later in the form of Citizens United and squash all that. And to me, very much the point of the book is to subvert that basic narrative that's completely wrong. So can you start by just helping us understand how corporations actually kind of started America?
Sure. Well, first of all, thank you. Great question. And thank you all for being here in the Brennan Center for organizing this. I am an NYU law grad. Well, I spent a lot of time with my friend Josh, who's sitting in one of the back rows there, hanging out in D'Agostino Hall many a Saturday night. So it's good to be back, you know. You're absolutely right. I mean, we have this image, this image of the Pilgrims who come over in around 1620, 21, and they land at Plymouth Rock, and they're sort of the perfect embodiment of what we think about America. They're trying to escape from tyranny. They're trying to exercise their religious freedom rights. They kind of represent what we think America would come to define itself as. But we have to remember that the first successful English permanent colony in the New World was in Jamestown. And it was founded, about 14 years before the Pilgrims landed at Plymouth. And Jamestown was founded by a business corporation, the Virginia Company of London. It was not an outcast looking to escape tyranny. In fact, they named their town Jamestown after the king. And the Virginia Company of London was one of the earliest joint stock corporations in England. It came to America specifically as a money-making venture. They sold stock on in London to investors, and the idea was to come here and to make money. It wasn't to come here and establish liberty. And so by the time the Pilgrims got to our shores to bring a sense of sort of religious liberty and fight against tyranny, the profit-seeking corporation had already latched its hooks into the New World.
And what that means going forward is really complicated, because it starts to mean that corporate values and even corporate charters actually wend their way into our essential documents about freedom, right?
That's right. It's one of the things I found is sort of one of the hidden influences that we overlook in terms of the written Constitution that was written by the framers during, just after the Revolution. The Constitution borrowed heavily from the corporate charters of the colonies. Many of the colonies were organized as corporations, as business corporations originally, and they had these charters. Corporations always had these charters that would limit what the power of the different office holders in the corporation would limit what they could do. And these charters, eventually, as those colonial corporations became governments in the colonial era, that idea of a charter, a written charter that would limit what office holders do and guarantee the rights of no longer investors, but now citizens, would really shape the framers and how they thought about the Constitution. They didn't phrase it in terms of we're borrowing from this corporate model, but England didn't have a written Constitution. Our written Constitution really came in fundamental ways from our experience in the colonies, and the colonies had charters originally because they were corporations. Now, of course, the colonies grew and developed, and there had been many years, about 100 years, where the founders and the colonialists were not focused on corporate charters, but that idea of the corporate charter did continue on.
Do you want to crush the souls of the young people in the first row and tell them about the first Thanksgiving?
It was a corporate affair.
Was it a deeply spiritual? No, why don't you tell them, and then we'll just watch them just.
Right. Well, days of Thanksgiving were actually pretty common in that era. That wasn't so rare to do. But the first Thanksgiving that was celebrated in the United States was at the direction of the Virginia Company, which had ordered people to give a day of thanks. And the same thing, by the way, we often cite Jamestown as the first representative democracy because they had the first meeting of the Jamestown Assembly in the 16 teens. And this was not the result of a progressive spirit of reform and individual rights. The Virginia Company was really struggling to bring over, to get investors in London and to send colonists over here because it was so dangerous. Everyone kept dying. And so they promised this idea of representative democracy, if you will, just to have a voice in how you can govern yourself as a way to attract people to come to the New World and to attract investors. And so that representative democracy, again, has at least ties to the business corporation.
So another myth that you puncture fairly thoroughly in the book is the notion that corporations are always aligned with the fat cat rich, small c conservative interests, and that, liberals are always opposed to them. And there's this clean divide that we have come to accept. Again, the narrative of Citizens United about, corporations versus the little guy. That's also not accurate.
Well, it's more complicated. There's a lot of different kinds of corporations, and indeed, through much of the 20th century, it was often liberals who were promoting the idea that corporations had rights. Now, they weren't necessarily framing it in those terms, but for instance, I tell the story in the book that a real key turning point in freedom of the press law was a case in 1936 decided by the Supreme Court called American Press Company versus Grosjean. And it was basically Louisiana newspaper companies trying to take on the demagogic governor and senator of Louisiana, Huey Long. And Huey long before Donald Trump, was a populist who railed against fake news. And he accused the Louisiana newspapers of lying. He said, and he hit them with an advertising tax, a tax on their advertising revenue. He called the tax a tax on, he said it should be called, quote, a tax on lying, 2 cents per lie. And the Louisiana news companies wanted to challenge that tax in court and argue that it was a violation of the Freedom of the Press Clause. But at the time, the law really did favor Huey Long, and one of the reasons why it favored Huey Long was because these were corporations that were asserting First Amendment rights. And the Supreme Court had previously said that corporations do not have these kinds of free speech rights. And so that case, one of the big issues that was argued, that case is often remembered for its influence on freedom of the press law, Rarely remembered is how much of the argument was focused on whether corporations could even assert this right whatsoever. And ultimately, the Supreme Court ruled that they could, and it's considered a great liberal decision for freedom of the press. And indeed, if we think about freedom of the press cases since then, almost all the big freedom of the press cases were brought by business corporations, media corporations, but business corporations. New York Times versus Sullivan, that gives the right to criticize public officials. New York Times is the party. The Pentagon Papers case. We've all been loving this movie, The Post, without remembering that The Post is a movie about a for-profit business corporation claiming First Amendment rights. So, the story is much more complicated when you look deeply.
And that, I think, at least partly explains, maybe you want to amplify, but certainly, again, in the cartoonish version of talking about Citizens United, we forget that an awful lot of the folks, the sort of liberal giants, the Lawrence Tribes, the Kathleen Sullivans, part of the issue for them, the real sticking point was the New York Times itself is a media corporation. It's not nearly as clean as the public story we were telling at the time.
That's right, and not clean in its roots either. One of the things I tell about in We the Corporations, the Supreme Court in the Citizens United case, really, for all the discussion about corporate personhood, the Supreme Court never mentions corporate personhood in Citizens United. It's just not there. One of the things the court does emphasize, though, is what's known as the listener's rights theory of the First Amendment. And this is the idea that speech is protected regardless of the identity of the speaker if it has value to the listeners. Right? And the Supreme Court said that it's not about the identity of the corporate speaker, it's whether their speech is valuable to society. That theory of the First Amendment really took hold in Supreme Court case law in a case in the 1970s called the Virginia Pharmacy case, which was a case that was brought by Ralph Nader to protect consumers who wanted access to drug advertising prices. Pharmacists weren't allowed to advertise their drug prices. And so Nader, representing a bunch of consumers, sued to challenge this restriction on advertising. And he won, and part of the reason he argued listeners' rights is because he was a consumer rights organization. They didn't want to represent pharmacists. That's not what they did. They represented the consumers. But because they represented the consumers, they were forced to kind of make this argument about listeners' rights. And so that victory ends up being used by corporations and by those who are fighting to expand the rights of corporations to say corporations have free speech rights too. The identity of the speaker doesn't matter.
So I'm going to ask you to do, before we get to the part that Michael promised, the mind-blowing part, which is just gossip about amazing characters. But I'm going to ask you to do 5 minutes of doctrine, because one of the other things that I think you confound with this book, and it's really counterintuitive and important, is the notion that the real original sin is corporate personhood. And that, the idea that Hobby Lobby, this corporation, that they have a seat in church and that they're a person, that is the sin here. And I think that you have this dialectic between corporate personhood on the one hand, piercing the corporate veil on the other, and I think that to me is the misapprehension that most is lodged in the public consciousness. Can you work through that with us?
Sure. No, this is a great question. One of the surprising things I found in my research and in my discussions, I see here in the front row we have Kent Greenfield, who's a law professor at Boston College and one of the leading thinkers on the rights of corporations and corporations more generally. And one thing in my conversations with Kent we've really talked a lot about is how to think about corporate personhood. What does it mean, and what would it mean to treat a corporation as a person? People think that Citizens United was because of corporate personhood, but as I mentioned, it's nowhere in the opinion is there any discussion of corporate personhood. So I think there's a lot of confusion about what corporate personhood is. It actually, despite all the controversy, it's a very well-established legal principle in the law of business and the law of corporations. If you go back to 1757, Blackstone in his commentaries on the laws of England called corporations artificial persons. And if you open up any introductory corporate law textbook that's read over here at NYU Law School in the Business Associations class, one of the very first lessons will be that corporations are persons for purposes of the law, which means they have some rights and some of the attributes of natural persons. Now, this doesn't mean that corporations are just like me and just like you. You know, if you prick them, they do not bleed, right? They are not human beings. It's to make a statement. What corporate personhood means, and what Blackstone meant, and what the corporate law texts mean, is that a corporation is its own independent legal, independent entity in the eyes of the law. And it's wholly separate from the people who compose it. The stockholders, the managers, the creditors, they are separate legal persons. And that idea of corporate personhood is fundamentally about separation from the members of the corporation is an idea that the Supreme Court has really lost sight of. That, in fact, the Supreme Court rarely treats the corporation as its own independent entity, wholly separate from the stockholders. More commonly, all the way back to the earliest corporate rights cases, we find the Supreme Court often saying, not that a corporation is a person, but that a corporation is an association of people, that the corporation should be treated as a pass-through, and that the corporation should basically be able to assert the same rights as its members. And this violates the key principle of corporate personhood, that the rights and duties of the corporation are separate from the rights and duties of the members. That's why in corporate law, if you slip and fall at Starbucks, you have to sue the company. You can't sue the individual shareholders. The shareholders have limited liability because they are separate legal persons with separate legal duties and separate legal rights. And in fact, I think one of the things that really surprised me when I went into it, there are a few cases in the history where the Supreme Court really does adopt this principle of corporate personhood. It says, we'll treat the corporation as its own entity and we won't look at it as a pass-through that can claim the rights of its members. And in those cases, few though they may be, the Supreme Court's generally limited the rights of corporations. Give you one example before, I know it's a long answer, but one example in the early 1900s, when Teddy Roosevelt launched his legendary effort to break up the trusts, he went after the tobacco trust, and the tobacco companies and subpoenaed the officers of the tobacco companies to testify. And the tobacco companies went to court and said, you can't have our own officers testify against us. That's a violation of the right against self-incrimination under the Constitution. And the Supreme Court rejected that argument. The Supreme Court said that it's not self-incrimination because the officers of the company and the corporation itself are separate legal persons. So you're not self-incriminating, you'd be incriminating another person. So that's just to highlight that when we divide and separate out the corporation from its members and treat it as its own legal entity, which is the whole idea of corporate personhood in corporate law, we actually find that the rights of corporations tend to be more restricted rather than more expansive.
And so just, I think I'm saying the same thing you just said, but I want to be super clear that the populist embrace of corporate personhood, at some points at least, is to cabin the expanding rights of corporations, right? That's so counterintuitive to the notion that, again, that we tell ourselves now that the real problem is corporate personhood. So what does that mean for conversations around amending the Constitution and the curative for the corporate personhood problem in Citizens United and Hobby Lobby?
Yeah, no, it's a great question. You know, and there are cases, by the way, where the Supreme Court has said that a corporation is a person for some particular legal reason, but then the rationale and reasoning of the court tends to treat the corporation like a pass-through. So take Hobby Lobby. The court says that corporations are people for purposes of the religious liberty, for the religious liberty law, the federal law protecting religious liberty. But the reasoning that the court uses is not that a corporation has religious liberty. The court says that the Green family that owns the Hobby Lobby has religious liberty. And so we have to protect their religious freedom by protecting the right of the corporation. So you do have that kind of pass-through that often works. In terms of personhood, yeah, I think that personhood is the issue that's gotten so many people riled up. And I understand it. And it's based on an idea that corporations shouldn't have all the same rights as you and me. And now there's a big move to amend the Constitution for a 28th Amendment. 19 states have endorsed a proposed 19th Amendment that would declare that corporations are not people and have no rights under the Constitution. And I think for a variety of reasons that amendment is not a great idea, as we can talk about. But I think just to even to introduce the idea is that many people think that that's the problem. And I think what they're responding to is not the idea that corporations have rights at all. Because I think most of us agree that corporations should have property rights. If the government comes and takes over a private company's land to build a park, if you take Google's Googleplex and decide to build a park out of it, you have to pay just compensation, don't you? You can't decide that a corporation will be guilty of a crime without giving them due process of law to protect their property rights. I think what's become so controversial is that the Supreme Court's been extending other kinds of rights that don't seem to be appropriate for a corporation. Things like religious liberty or political speech in Citizens United. And that's why I think that controversy has really arisen around those kinds of rights rather than the traditional property rights that I think most people think corporations should have.
So I guess I have to ask the follow-on, which is, if amending the Constitution isn't your fix, what's your fix?
Yeah, well, I'll leave others to figure it out, but I'm a historian, and that's my way out. I mean, I do think so. I think the way to start, the way to think about these problems, I would say two important principles. Number one, take corporate personhood seriously. The question when we're asking about whether Exxon has constitutional rights is not about whether Exxon's members have constitutional right. There's some of you who are members of Exxon and don't even know it, right? I mean, you invest through pension funds or mutual funds and you don't know where your money is invested. I don't think we should think about corporations as a pass-through the way the Supreme Court has. In part because, by the way, if you treat a corporation like a pass-through and give it the same rights as the people within it, well, those are real people. And if they're people, and that's the basis upon which corporate rights are granted, of course they're going to have expansive rights of people. I think what we should do is, the real question is, which rights should a corporation have, the corporate entity? And I think there are some rights it should have and some rights it shouldn't. And that's my second principle, would be at least the starting point. I don't think it's the ending point in all cases, but the starting point would be a distinction that the Supreme Court drew about 100 years ago. So about 100 years ago, the Supreme Court was in the midst of its most business-friendly period in history, famous among law students and historians as the Lochner era, roughly 1890 to 1937. And even though the Supreme Court was very business-friendly, maybe because it was business-friendly, corporations flooded the courts with claims of constitutional rights, from equal protection and due process and First Amendment and criminal procedure protections, a whole series of cases in that time. And the Supreme Court drew a line. The Supreme Court said corporations have property rights, but not what the court called liberty rights, rights associated with personal conscience, political freedom, or bodily integrity. For a while, the court really stuck to that line. And I think it provides at least a basis for beginning the conversation about corporate rights. They should have rights of property, and they should be presumed to have those rights. And they should be presumed not to have liberty rights, although there may be some exceptions, as you look deeper into it. But that basic, think about what rights are appropriate for the corporate person, not for the corporate members. And think and start with the presumption that corporations are entitled to property rights, but not liberty rights.
I want to get to the gossip now.
Gossip.
Just because
this is the fun part.
This book is just, it is such a fun book, even if you're not a law wonk, because it's just teeming with unbelievably interesting characters. And I thought maybe we could start with Roscoe Conkling.
Oh, my favorite.
Because it's just such an extraordinary story. And I bet a lot of people here don't know yet about Roscoe Conkling. So can you tell us a little about that?
And thank you for the compliments on the readability of the book. The most gratifying thing of some of the early reviews that have come out are people saying how accessible it is and how fascinating and engrossing it is. When you're a law professor and you're writing, you're not expecting that kind of response, believe me. So very, very gratifying, of course. But yeah, Roscoe Conkling. So Roscoe Conkling, very interesting fellow. So he was a leader of the Republican Party in the 1860s and 1870s. And he was even nominated and confirmed to the Supreme Court of the United States. And he refused to serve after having been confirmed, the last person ever to turn down a Supreme Court seat after being confirmed. And the reason why he turned it down is because he was making too much money as a lawyer for the big railroads, like the Southern Pacific Railroad. And the Southern Pacific Railroad hired Roscoe Conkling and an all-star team of great lawyers, illustrious lawyers, to win new rights for corporations. The 14th Amendment, as many of you know, was adopted after the Civil War to protect the rights of the newly freed slaves. Roscoe Conkling went to the Supreme Court and argued that the 14th Amendment was also written to protect business corporations. Now, it may seem like an absurd argument. The 14th Amendment refers to the rights of persons. But Conkling was an unusual fellow. He had been, as a young congressman, on the drafting committee that had written the 14th Amendment. And he was the last surviving member of the committee. And so there was no one to refute his story. And he even brought out a journal. He said it was a never-before-published journal of the deliberations of the drafting committee of the 14th Amendment. And if you looked at that journal closely, you'd see he said that the language of the 14th Amendment had been changed from the word providing equal protection to citizens to providing equal protection for persons. He said specifically to, quote, embrace artificial persons as well as natural persons. Now, it turns out that historians have gone back and looked at Conkling's claim and his evidence, and it turns out that Roscoe Conkling just lied to the Supreme Court of the United States. That the language of the Equal Protection Clause was never revised in the way that Conkling said, that no drafter at all, including Conkling, had for over 15 years even mentioned that the 14th Amendment might impact corporations. And one historian who looked most closely at this story and debunked it said that Conkling had engaged in a, quote, deliberate brazen forgery to win new rights for corporations. He was ultimately successful, by the way, because of another bizarre turn in that case. It was a case brought by the Southern Pacific Railroad, and the Southern Pacific Railroad brought 60 cases, what the lawyers called test cases, to challenge a California law seeking new rights for corporations. A few years after, the Supreme Court never rules on Conkling's case for reasons that are not clear, although I suspect that it was because his fraud was uncovered. But a couple years later, another one of the Southern Pacific's test cases gets to the Supreme Court. And the Supreme Court decides that case in favor of the Southern Pacific Railroad, but specifically says in the opinion, we are not reaching the constitutional issue here. It's a statutory issue, they could handle it on. Yet the reporter of decisions, the guy who writes up the summaries of the Supreme Court opinions and publishes the official volumes, included in the summary a statement that the court had held that corporations were persons under the 14th Amendment, something the court had clearly not held. And a few years later, one of the justices, Stephen Field, one of the most colorful justices ever to be on the Supreme Court, the only sitting justice ever arrested while he was on the Supreme Court, and the charge was murder. Interesting guy, right? Carried a gun underneath his robe at all times, you know, a fascinating character. And he was determined to expand the rights of corporations. And he, in a case a few years later, he cites the Southern Pacific case, a case that he knows does not hold this principle. And he says, we decided in that case that corporations had rights under the 14th Amendment. And in the years that follow, there would be, by 1912, a study of Supreme Court cases found that there had been, since 1868, a grand total of 28 Supreme Court cases on the rights of African Americans under the 14th Amendment. But by 1912, over that same period, there had been 312 cases on the rights of business corporations.
Yeah, that's the gobsmacker. Sit with that for a second. Okay,
312.
while you sit with that, I'm going to just remind you, this is NYU Law School's Brennan Center for Justice program. We're talking to the wonderful Adam Winkler, who teaches law at UCLA. He's author of the new book, We the Corporations, How American Businesses Won Their Civil Rights. I'm Dahlia Lithwick, your moderator, and you can follow NYU Law School's Brennan School for Justice on Facebook and Twitter and watch and listen to all their programs on iTunes, YouTube, and their website at brennancenter.org. So, Adam, you have just suggested that this idea is kind of a fraud with the GUI fraud center. That we have, you know, case notes suggesting something, and baked into the middle of it is an oral advocate who just lied. That story got a lot of play, I remember, at the time of Citizens United. Does it matter?
Does it matter? I mean,
It's the existential part of the
right?
show.
Yeah. Does it matter? Does it all matter? But it's interesting. I think it certainly it matters. I mean, does it matter that he lied? I mean, no, in the sense that a few years later, the Supreme Court, maybe Stephen Field and misleading readers, but he was writing majority opinion. And after that, the Supreme Court had 312 cases afterwards where they ruled on the rights of business corporations. Clearly, it captured the mood of the Supreme Court and that corporations did have rights. And while the initial case is very iffy, the court in that period really was committed to protecting the rights of corporations. And so in that sense, it didn't matter that much. But what a fun story nonetheless.
Yeah,
I mean,
yeah. No, it's fantastic. So now in our continuing to gossip, can you tell us a little bit about Daniel Webster, the hidden history? I think that you call him the Constitution's, the corporation's lawyer?
So he was known as the defender of the Constitution, Daniel Webster. So Daniel Webster was one of the greatest advocates in Supreme Court history. He argued more than 220 Supreme Court cases in the early 1800s, roughly from 1815 to 1850, at a time when so many of the Constitution's provisions were first being interpreted. And he was one of the most authoritative voices on the Constitution. But I say in the book that he could have been called the defender of the corporation, because almost all his clients were corporations and big businesses. He was one of the illustrious lawyers of the day. And one of the things I talk about in the book is that you can't underestimate the role that lawyers have played in this struggle for corporate rights. You know, unlike women and minorities, corporations don't agitate for their rights in the streets. They don't parade down Main Street with signs demanding equal rights. There's not a corporate rights movement, if by that we mean a mass mobilization of corporations. The Pillsbury Doughboy is not out there marching, right? But they've won their rights by persistently pursuing Supreme Court decisions, recognizing them to be protected by various provisions of the Constitution. And this is a totally lawyer-dependent story. Every great civil rights movement needs great lawyers. You think of Thurgood Marshall in civil rights or Ruth Bader Ginsburg in women's rights. And the same was true in the corporate rights area. You needed lawyers to devise the novel legal theories, to persuade the justices. And Daniel Webster was among them, and he argued a number of important corporate rights cases in the early days of the Supreme Court, and lost a few too, by the way. In the Marshall Court, was known for being very expansive on the rights of corporations. But the Taney Court that followed it, Taney much reviled today for his opinion in Dred Scott, the Taney Court, Taney was a corporate reformer who opposed expansive rights for corporations and so really tried to restrict them. But Daniel Webster was certainly one of the great advocates, and the story I tell is fun because it's about his, he has a close relationship with Chief Justice Marshall, and he is the enemy and rival to Taney. In fact, Roger Taney was the first cabinet appointee ever to be rejected by the Senate for confirmation. And it was Daniel Webster who led the charge. And then eventually Taney gets on the Supreme Court and Webster has to appear before him. There's a moment where Webster says, this is in a Supreme Court case, where he's standing before the justices and he says, it's a little, I'm paraphrasing, he says, it's a little awkward to be here because I've had the pleasure of voting against every single one of you to the Supreme Court. Not a good opening line for your client, I guess.
I think the last person I want you to talk about is Lewis Powell, just because it becomes so central to what we now think of as the sort of Chamber of Commerce victory, the victory of, the ascendancy of corporate power in America. So can you fill us in? Because I think people know the outlines, but
right. No, and Lewis Powell is really definitely one of the fascinating figures in this story. Lewis Powell was a Supreme Court justice appointed by Richard Nixon, and was known as being somewhat socially liberal for a Nixon appointee, but he was very expansive on the rights of corporations. Just 3 months before Lewis Powell was nominated to the Supreme Court, he wrote a memorandum at his own will, his own suggestion, his own impetus, wrote a memorandum to the Chamber of Commerce. The memorandum was taking on the fact that, this was written in 1971, that it was a time of rising consumerism, environmental protection. The left was on the move, right? Michael's going to, and the Brennan Center are going to have these events on the 60s. Well, the 60s were so promising for progressives because they were really on the move and we had all these good laws that were getting passed. And Powell writes this memorandum about how corporate America can fight back against the liberals and the leftists and the Ralph Naders of the world. And that document ends up becoming a very influential planning document for the rise of the new right in the 1970s. And it gets distributed among corporate leaders everywhere, and it becomes really famous and an influential memorandum. And then 3 months, but before it becomes famous, he gets appointed to the Supreme Court. He's on the Supreme Court. And then a fateful case comes before him, a case called First National Bank of Boston versus Bellotti. And this dealt with the speech rights of corporations 30 years before Citizens United. And the Supreme Court, in an opinion by Justice Powell, holds that corporations have political speech rights equivalent to those of individuals, at least in the context of ballot measure campaigns. Citizens United will expand that to candidate elections. But Citizens United really is just sort of the logical next step from Powell's opinion in the Bellotti case.
I want to, before we go on to this.
Can I tell one more Powell story?
Please, that's why we're
One
here.
of my favorite things.
Tell two more.
One of the favorite things I found in researching Powell is Powell, before he joined the Supreme Court, was on the board of directors of Philip Morris, the tobacco company. And all of Philip Morris's papers from that era are all available to researchers because they were part of the tobacco settlement. And so you can go online and so I'm going through these documents, and I found the most amazing thing. It was a transcript, like a 10 or 12 page transcript of a multimedia toast that the head of Philip Morris gave at a sending off party for Lewis Powell after he had been confirmed to the Supreme Court. And it goes through all these, like, the incidents in his life, and like it starts with, oh, here's where you met your wife, and you go to ask for your girlfriend's hand in marriage. Go to her father and ask, and he says, of course. She tells me you are a Supreme Courter. You know that kind of thing, just like silly jokes and stuff like that. But the thing that's remarkable is at the end of this toast, the head of Philip Morris says it's traditional for a justice's friends to give him his robes of office. And Lewis Powell comes up onto the stage at Philip Morris's annual luncheon and is given his Supreme Court robe by the chairman of Philip Morris. And it's just kind of a nice symbol of sort of the rise of corporations and coming back against Nader.
It's funny because after Citizens United, you probably all remember the cartoons that went round with the justices with all the decals, right, from all the corporations.
I did that as a Halloween costume one year.
I'm sure
no
you
one
did.
got it.
I'm sure you did.
It's like my wife's like, you're such a wonk.
Yeah, I'm surprised you don't do that every year. But it is interesting because it's such a metaphor, and also maybe a useful reminder that one through line through this book is tobacco. I mean, this is, again, to the extent that this country is founded by a corporation, tobacco's in it to win it from the beginning, right?
Right, becomes very influential in the Virginia Company, runs right up through the tobacco companies, bring the first criminal procedure cases to the Supreme Court, trying to claim the rights of criminal suspects. Philip Morris and the relationship with Lewis Powell is, of course, essential. And even today, tobacco companies use the rights that Lewis Powell and the Supreme Court gave them to fight off laws, say, requiring graphic warnings on cigarette packs, which have been struck down on the basis of First Amendment rights of business entities.
I want to make very explicit something you said implicitly, but I think it's such a cornerstone in framing this argument, and that is the point you make about the 14th Amendment. That the 14th Amendment is, adopted to first and foremost help freedmen. It becomes weaponized to help corporations. And I think what you said was, but I want to hear you say it, that's because corporations have money, Dahlia. That's the answer, right? That you have this lever that's an incredibly powerful lever that you've given us the numbers, is all out of proportion to what the framers, I think, expected, becomes a tool of just moneyed interests, right?
That's right. I mean, when we think about corporate power, we often think about the political process, corporations expending money on elections or lobbying and getting lawmakers, legislative officials, elected officials to follow the corporate will. But part of the story I'm telling in the book is that corporate power is also a story about corporations in the courts. and that the court system is actually uniquely designed to help corporations. Although it has this idea and attitude of equality and blind justice, the truth is the reason why there were 28 African American cases in the Supreme Court under the 14th Amendment in the first 50 years and 312 from corporations was because there's no money to back up the litigation campaign for African American rights at this time. And there's a tremendous amount of money from corporations to back the claims for their rights. And it goes back to the very earliest days. I mean, the first Supreme Court case on the rights of African Americans, 1857, Dred Scott versus Sanford, and Dred Scott loses. The first Supreme Court case on the rights of women, Bradwell versus Illinois, 1873, Myra Bradwell loses. The first case on the Supreme Court case on the rights of corporations is decided a half century earlier in 1809. And the corporation wins. So from the very earliest days, corporations are really pursuing aggressively to take advantage of these rights that were designed for more progressive principles and more progressive purposes. And I find that an interesting dynamic. There's times when the corporations are really good, what I call constitutional leveragers. They use Ralph Nader's listeners' rights theory to expand their own rights. They use the 14th Amendment designed for progressive causes to serve the ends of capital. We see that over and over again. At the same time, one of the interesting things I found, Dahlia, was that corporations are often constitutional innovators too. Because they have that money, because they're pursuing this aggressive litigation campaign throughout the years, they're actually first movers. They develop some of the and use civil rights litigation strategies that would be used years later by the civil rights movement and women's rights movement. Test cases and all-star teams of lawyers making novel, broad interpretations of the Constitution. We often think living constitutionalism is about protecting minority rights or women's rights that weren't intended by the Constitution. The truth is the Supreme Court's constantly read this Constitution broadly to protect the rights of corporations, who clearly were not part of what the framers were thinking of when they wrote the Constitution.
It's such an important point, and it dovetails with what we said at the beginning, that I think it's important to understand this is such a complicated narrative, and that sometimes corporations are drivers of real fundamental constitutional movement. I want to give you, and we're going to take questions in a second, but I want to give you a chance to talk a little bit about the cases on the docket this term. And there are two that I'm thinking of, one of which is Masterpiece Cakeshop, and this is the cake baker who wants to have a right of conscience to withhold service to a same-sex couple and does not want to provide them with a wedding cake, and that case is now pending at the court. One of the things that you talk about is that that's got some antecedents too.
Yeah, no, indeed. Masterpiece Cakeshop is an interesting case. You know, there's been a spirited public debate about the rights of the baker, the individual baker, but as the title of the case indicates, it's also brought in the name of a corporation. And Masterpiece Cakeshop Limited, a corporation, is one of the people whose First Amendment rights are alleged to be infringed by Colorado's law requiring you to serve people without regards to sexual orientation. So it's kind of a corporate rights too. And interesting thing about that case is that one interesting aspect of it is that none of the justices in the oral argument really focused, well, maybe one or two, but for the most part, the justices did not focus on whether it was a corporation involved. And what we often find is that corporations are often involved in constitutional law cases, and the court doesn't even ask whether a corporation has those rights. My book focuses mostly on, actually exclusively on cases where they specifically and explicitly address the question of corporate rights. So that's somewhat different. But Masterpiece Cakeshop does have an antecedent. In 1907, the Supreme Court during the Lochner era held that a corporation did not have a constitutional right to refuse service to unwanted customers. Corporation in that case was the Tanforan Racetrack in California, home of the legendary Seabiscuit. And California at the time had a law requiring places of public amusement to serve anyone with a valid ticket. And they wanted to keep someone, a competitor, out of their grounds. And they challenged this California equal access law saying it's a violation of their fundamental rights under the Constitution. It was like forcing a newspaper man into a private company's property and a private home's a dinner at a private home or something like that. The Supreme Court rejected that argument in part because, remember, the court was holding to the line. You have property rights, but you don't have liberty rights. You don't have the right of association to just deal with only the people you want to deal with if the state has determined that you should be open to all.
And can you talk for a minute? I know it only happened yesterday, but it feels like 1,000 years ago. But the court heard argument in Janus, which is the challenge to the agency shop rule in public sector unions. And this question, I think that will, if things go the way it looked like they went yesterday, probably lead not just to the dismantling of public sector unions, but unions generally. But really interesting colloquy between Justice Kennedy and David Franklin from Illinois, sort of suggesting, I think, that Justice Kennedy just feels that he's well aware that this will be the demise of unions, and that's good because unions are bad, horrible, blood-sucking entities, and in dramatic contrast to how he thinks about corporations and Citizens United. Do you want to talk a little bit about any of that?
Yeah, sure. No, it's really interesting. So I pay special attention in the book to efforts to regulate corporations in politics, because that's obviously something that's a central concern to us. And among that story, if we think about corporation in politics, there's often a linkage between unions and corporations. So in Citizens United, for instance, the court said it's taken as a corporate rights case, but the court also said unions have the same right. And throughout most of campaign finance law, that's what we've generally had, unions and corporations treated the same. What's happening in the Supreme Court in recent years, though, is that the rights of corporations are expanding and the rights of unions are being more limited. And we're seeing the political power of corporations expand while the political power of unions is going to decrease. And some of the same ideas that are motivating the court to limit the rights of unions, right? That is like protecting the dissenting member who doesn't want to support politics. The court has turned a blind eye to in the corporate context, when the truth is many of the quote-unquote members of the corporation, the shareholders, really don't have much voice, are dissenting themselves, and have no ability to remove themselves from the corporation because they invest, say, through a pension fund, and they don't have control over where your particular dollars are invested in a pension fund. And so we'll have to see. I mean, I wonder if the court will articulate principles in this union case that might be used to then push back against Citizens United, but we'll have to see.
We're going to take questions. I'm going to ask you humbly to frame your question in the form of a question. And just know that there's an awful lot of people and not so much time, so to the extent you can sort of just be as brief as you can, that would be awesome. Brennan, is there a microphone, or are people just standing up to, yes, there's a microphone coming. We're in a foot race between a camera and a microphone. So do you want folks to queue up? Is that the best thing? All right, so maybe if you don't mind queuing up at the mic, and yeah, to the extent that you can be as brief as possible. So, and maybe existential questions, one per customer, just because those take a long time. Okay.
How would Rehnquist have decided Citizens United?
Yeah, that's a good question. You know, one of the surprising things I found is that Chief Justice Rehnquist was an opponent of rights for corporations and dissented in cases where the Supreme Court was expanding the rights of corporations, including the Bellotti case, a case that might surprise some people. And in fact, it just highlights that it's not, the story of corporate rights is not so reductionist. It's not all liberals on one side, all conservatives on the other, and that this actually divided people in unusual ways. But Rehnquist was an opponent of corporate rights. How he would have ruled in Citizens United, a little hard to say, other than we know he was an opponent of corporate rights. There was an opinion towards the very end of his tenure where he seemed to backtrack a little bit on it, so we're not 100% certain.
Thank you.
Yes, sir. My name is Christopher Vicciola, and I'm involved with Senator Chris Murphy and Senator Richard Blumenthal with gun legislation. And I did read your biography. Do you feel that the NRA is a corporation that is influencing politicians?
So yes, clearly, hey, thanks for that easy question. Yeah, no, it is, but I think it's actually important to point this out, right? So the NRA is it's not a business corporation, right? It's a different kind of corporation. And one of the things that I talk about in the book is that often the Supreme Court has paid little attention to the differences in the kinds of corporations involved. And so when the court has expanded the rights, for instance, of the NAACP in the civil rights era, corporations are then able to use those same rights to expand their own legal protections because the court doesn't always differentiate between these different kinds of corporations. One thing I think that we see not only is the NRA influencing politics, but at this moment, we're also seeing a lot of business corporations trying to influence the gun debate the other way. Right? By withdrawing money and playing a role in politics. The story of the corporation in politics is complicated, right? It's not just corporations winning protections against environmental rules, although it is that too. It's also corporations fighting against the NRA today. It's corporations that last year were fighting against anti-transgender bathroom bills and forced North Carolina to back down because the corporations were exerting political pressure and political power. So sometimes the responsiveness of corporations to their customers can lead corporations to do the right thing. I think what's worrisome is at the end of the day, it's not done because it's the right thing. It's done it because it's in pursuit of profit, of brand management, and that's not the basis upon which we want public policy made.
So toward the end of your lecture, you were talking about the cake case where it's possible that this business might actually end up not having the right to deny homosexuals of their right to have a cake baked for them. But if I walked to the local delicatessen and started picketing and saying whatever I wanted to say on my mind, they had the right to kick me out of the store, right? I lose my First Amendment rights at the door. But at the same time, homosexuals do not lose their 14th Amendment rights at the door, and nor do other people. So where do we draw the line as to what amendments are in businesses and businesses have the right to deny their customers?
A good question, yeah. I mean, the difference is that, yeah, you could be kicked out of the local store for protesting and disrupting business, and their kicking you out doesn't violate any law. Right? They're allowed to do so. There's no special law that says you can exercise your First Amendment rights inside of the Korean deli on the corner. But there are laws, and Colorado has adopted one, saying you cannot discriminate on the basis of sexual orientation. And we've had these debates before. You know, it seems somewhat new to be debating whether a business corporation can discriminate because of its constitutional rights. I mentioned not even to go back to the 1907 case that I mentioned, but you know, in the civil rights era in the 1960s, there were a whole wave of cases brought by businesses challenging the Civil Rights Act, and they claimed religious freedom, freedom of expression, mostly freedom of association. That was the big right they emphasized at the time, but it was First Amendment rights, not to serve African Americans. And the Supreme Court and the lower courts turned away those challenges time and time again. It was really interesting in the Masterpiece Cakeshop case, Dahlia, I know you were there, all of the lawyers involved in that case, no matter who they were representing, on which side of the case, all of them got to the podium and said, no, you couldn't do this in the context of race. We would not give the baker the right to discriminate on the basis of race. It's unthinkable. But the reason it's unthinkable is because the Supreme Court and the courts said you couldn't do it time and time again in the 1960s. So it became unthinkable. If the Supreme Court allows it to happen now, it will not be unthinkable in 20 or 30 years. It'll be thinkable because the court has allowed it to happen.
And I would just add, just because I think it's so interesting that this doesn't come up as a conscience case or a religious dissent case. This is not Hobby Lobby, this is speech. And it's a fascinating turn in the case that it becomes about a cake artist, and that's how it's construed. And so it really does become, I think in this theme of weaponizing First Amendment claims to sort of swallow other interests, that this is no longer about a religious objection. This is somebody who says he is being compelled to speak, which led us into this rabbit hole of, is flower arranging speech, and, folding napkins, is that speech? But I do think it goes to this, this really complicated question about how speech has kind of swallowed everything. It's a great question, though.
And remember, in all the race cases, we all study them in law school. The Supreme Court was so committed to the idea of the 14th Amendment protections against discrimination that they rejected these association claims time and time again. They were brought over and over again. I'm just not sure that the court is as committed to that principle today.
All right, thank you.
Thank you.
Hi, since you brought up the Janus case, I was curious what you had to say about how the First Amendment is somewhat being used against itself as like freedom of assembly pertains to unions as opposed to the right of free speech, which is the individual. But the whole point that unions exist is so that the power of the many is not drowned out by the powerful few. So I was just curious, like, what you felt about the First Amendment being used against itself with different clauses.
Well, there's, the First Amendment. I talk about the rise of the First Amendment in the book. It's really driven by concerns about the rights of socialists, of anarchists, of communists, of dissenters. Marginal voices led the Supreme Court after the Red Scare of World War I to start protecting the freedom of speech. And the first cases that provided protection were decided in that era. But today, the freedom of speech is used, if not the majority of time, nearly the majority of time, by businesses and trade associations. A recent study found that about 50% of all First Amendment cases today are brought by corporations and trade associations. So this First Amendment that was designed to open up the marketplace of ideas for these dissenting voices who are challenging government orthodoxy is now used primarily by corporations and trade associations to try to fight off laws that were adopted by we the people to protect the interests of consumers and investors and the environment.
You've spoken very interestingly about how corporations have made use of the First and the 14th Amendments. I was wondering, kind of in a way referring back to your earlier book, have there been any cases when corporations have actually made personal use of the Second Amendment? And if not, can you imagine circumstances in which they might?
Right. There's some rights that corporations should definitely not have, like the right to vote, the right to run for office. I guess they don't need the right of sexual privacy. And they don't have the right to keep and bear arms yet. Right? I mean, we haven't seen it. But I do think, if you wanted to think about whether corporations have a right to bear arms, I can't imagine, it's hard to imagine what case comes up. Maybe some place that refuses to allow a corporation to have armed security, where you might see a corporation bringing a Second Amendment case. You could imagine maybe in the war against Planned Parenthood today, that maybe some state will say Planned Parenthood can't have armed guards in front of it. I can't imagine that's really going to happen. And you can imagine Planned Parenthood saying, well, we're a corporation, not a business corporation, but a corporation, and we should have that right to have armed security, which might tie into something like that. But so far, we haven't seen too many corporations. Maybe when the Pillsbury Doughboy, he's not going to march with a sign demanding equal rights, but it's America. He'll march with a gun strapped across his shoulder, and, that's America.
And on that totally apocalyptic note, yes?
To follow up on a number of the questions that have been asked, I was with a group of activists the other evening who have taken on a particularly deep-pocketed opponent, and they were very concerned about being sued. And another lawyer in the room said, well, you should incorporate, and then you'll be protected. So I wondered if you, in your distinction between business corporations and other corporations, if you could say a word about the possibility of using the corporate structure in order as a vehicle to advance individual liberty and protect individual liberty.
Yeah, no, that's a great question. And indeed, the corporate form has been used over time to advance individual liberty in some instances, right? When we talk about the corporate form, you can't help but talk about, as I do a little bit in the book. My book focuses on business corporations and how these rights are used primarily by business corporations, but there are also other kinds of corporations. I have a chapter about the NAACP and its fight for rights for voluntary membership associations that take the corporate form. And when we think about it, I mean, Planned Parenthood is a corporation. It's incorporated. The NRA is incorporated. That the advocacy groups we rely upon to accentuate our voice in a democratic society are often corporations, not business corporations. And I think one of the problems with Citizens United is, to the extent that Justice Kennedy analyzes the nature of the corporation at all in Citizens United, which is not very much, but to the extent he does it all, he says that a corporation is an association of citizens, a disfavored association of citizens, and cites to the NAACP cases. We shouldn't think about business corporations in the same terms that we think about when we think about nonprofit advocacy organizations, even if they take the corporate form. It's one of the reasons why I think we should focus on what rights are appropriate for the corporate entity. There are different kinds of corporate entities. There are for-profit businesses, there are not-for-profit businesses. The tax code makes these distinctions all the time and has for many, many years. It's not hard to do. It's a distinction between different types of corporations that the Supreme Court has often omitted. Thank you.
We have a hard out in about 5 minutes. So to the extent that you can, and I'm going to give up my moderator prerogative to ask the last question, but to the extent that you can zing through these, let's zing, shall we? Okay.
Thank you, Professor Winkler, for sharing this niche, or maybe it's a niche of expertise that you've developed with us. I had a quick question about the changing role of the corporation over time. You mentioned how much influence corporations had at the founding, and my understanding is that corporations function more as public benefits and sort of in some ways as a form of stepping in for governments at that time. And can you talk about when corporations shifted to the form that we see today, where there are sort of massive instruments for generating profit?
That's a great question. My former star student, Artin, thank you very much. That niche thing was a little inside joke about a bit I do in my first year common law class. When did corporations change? It's true that corporations have been with us for a long time. I found in my research that the earliest corporations were formed in Rome 300 years before Christ. And even back then, by the way, they were valuable as an economic tool, but also a threat to the health of society. Ice core samples have been recovered from that era, and they find evidence of large, wide global pollution created by the Roman mining corporations of 300 years ago. So even back then, corporations were problematic. But the traditional rule, if you go back and read Blackstone, Blackstone says corporations can only be chartered by the government and will only be chartered if there's a public purpose. You have to be pursuing a public purpose, not just making money. It was always about making money too, like that was nature of the corporate form, especially when you move to stockholding corporations in the mid-1500s. Yeah, it's about making money for sure, but the investors could make money, but it had to pursue a public purpose. That really changes. First of all, it was always a little complicated. There were private corporations that were sort of existing without a public purpose before then. But it really changes in a case argued by Daniel Webster, known as the Dartmouth College case, Dartmouth College versus Woodward, where representing not a business corporation, but Dartmouth College, which was organized as a corporation, argued that businesses New Hampshire tried to take over Dartmouth College, and Daniel Webster said, you can only take it over if it's a public entity, but if it's a private entity, it's like an individual, and you can't just take it over if you're the state without paying compensation. He wins that case, and that case, although it's about a college, is famous in the literature already for providing rights that corporations would use in the years later, business corporations, to protect themselves against efforts by the state to regulate or to impose new duties upon them. So the shift really happens in the early days of America, where corporations really become private entities without any kind of public purpose anymore.
Thank you.
Hi, thank you for today. I found that it was really interesting when you mentioned how corporations are not out there marching, which is quite true, and yet their interests are advanced. And I wonder whether you think there is an approach that different social campaigns, and different groups that promote minority rights, whether there's an approach they can take that models that type of advancement that corporations do.
Well, I will say there's elements. So one reason why corporations were successful when many other civil rights groups were not as successful is, I said, in part because of money. Obviously, these larger ideological trends and things like that, I don't mean to push those aside, but they always had the money to have the best lawyers make the most creative arguments and push it. And civil rights groups traditionally didn't have much money, were underfunded, under-resourced, and couldn't bring those cases as vigorously as corporations could. But we're seeing that really change, and that we're seeing that now these days we're finding a real professionalization of the litigation teams for public interest organizations. They're getting the best and brightest lawyers to bring the cases on behalf of LGBT rights and transgender rights. That you now have the Ted Olsons and the David Boyes coming together to form a dream team to fight for marriage equality. You're now in the civil rights space more generally. You're seeing civil rights organizations do what the corporations were always doing. They're not mimicking it, mimicking corporations self-consciously, but they're doing what the corporations. Let's hire the best private lawyers that money can buy, or that were willing to volunteer their time to defend ourselves and defend these interests in court. Studies show that the members of the elite Supreme Court bar are especially good at getting their cases accepted by the Supreme Court. So maybe that's something that will actually benefit some of the civil rights group. Of course, there's one problem, Dahlia, which is the justices that will decide the case when the civil rights case goes to the Supreme Court. Yeah, that's not good. Yeah.
Okay, I'm getting the wrap sign. Can we take one more quick question? Let's do one more quick question, and then Adam's going to sign books outside, so you can just sit next to him and hound him out there. But let's do one more question, and I'm sorry about that. Go ahead.
Hi, Professor Winkler. It's good to see you somewhere where LA winter has moved right along to this coast.
Another star student of mine.
Thank you. I was just wondering, because you've been discussing the different ways in which traditional business corporations and other corporations, whatever you want to call them, have been piggybacking off each other's work in the federal law in terms of the case laws that they're making, and I was just wondering whether you've seen any distinctions in the patterns that the two groups, the business corporations versus the 501c3s and their cousins, have been developing.
Yeah, no, that's a good question. And historically, there have been those distinctions made. For a long time, the Supreme Court said that nonprofit membership associations did have the right to spend money on electoral politics because they represented their members, and that was a pretty sensible distinction, because the NAACP taking out money, taking out ads to represent the interests of its members makes sense. And what we see is that that distinction gets discarded in Citizens United, and the court says that the for-profit business corporation will be treated the same as what was a special rule for nonprofit advocacy organizations. So you definitely see that breakdown of that distinction that had separated out those rights. So in some ways, maybe we're seeing more convergence rather than differentiation among those different kinds of corporations. Thank you.
So I want to take a moment to thank the Brennan Center and NYU Law School and all the good people who organized this event. And I want to thank and congratulate Adam Winkler, UCLA law professor, author of We the Corporations, How American Businesses Won Their Civil Rights. You should each buy 7 of those books outside. I'm Dahlia Lithwick, and on behalf of the Brennan Center and the audience right here at NYU Law School, and to those of you listening online, have a good night, and thank you so much for coming out.
Thank you. Thank you, Dahlia.